Hello and good afternoon on a rather warm afternoon. My name's David Winch from Bartfields Forensic Accountants, and this webinar, which will be about half an hour, is going to deal with some more leading cases in confiscation. We will be looking particularly at proportionality and mortgage fraud. So let's have a look at the agenda. Quick introduction and then proportionality in confiscation. We're going to talk obviously about the Weyer case, but we're also going to talk about some other recent cases or more recent cases which have built on Weyer and move things forward. And then we're going to have a little bit of chat about the benefit of mortgage fraud, which was of course dealt with in Weyer, but wasn't in Weyer a point on proportionality. There were other points in relation to mortgage fraud that arrived in Weyer, and also there are subsequent cases which have dealt with rental income in connection with mortgage fraud and so on. So we'll get into all of that, and then I'll remind you of how Bartfields Forensic Accountants can be of assistance to you. So let's go. Again, today we're going to do these topics because they cause a bit of confusion in confiscation. And indeed, in a fortnight's time, we shall be doing some more topics from case law, which are causing some confusion in confiscation cases. And on that occasion, I plan to be dealing with money laundering and issues around that. Obviously, we need to look at both the statute law and the case law, although we're always going to remember that in the case of May, the House of Lords, as it then was, the Supreme Court, reminded us that it's necessary to look carefully at the statute and not to be misled, if you like, by case law, which can have various different interpretations. But if we look at the statute, we shouldn't go far wrong. All the cases that I'm going to mention today, the judgments can be found online for free on the Bailey website. Right, the whole issue of proportionality derives from the first protocol to the European Convention on Human Rights, and indeed from Article 1 of that first protocol. And it's worth looking at that in full. What it says is this: every natural or legal person is entitled to the peaceful enjoyment of his possessions. No one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law and by the general principles of international law. So what we're looking for is some sort of a fair balance between the individual's right, if I can use that word, to keep hold of his own possessions, and the state's right to dispossess him in accordance with law. And there has to be a reasonable relationship of proportionality between the means employed by the state and the aim sought to be realized by any measure depriving a person of his possessions. So we are asking ourselves, if confiscation under Proceeds of Crime Act deprives a person of his possessions, why is that? What is the justification for that? What is the aim of the state? What is the state trying to achieve by doing that? And is the way that the law operates proportionate to that means, to that aim of the state? Of course, this was considered in the case of Weyer, and the full reference is there if you want to look it up on Bailey. And as a result of what was said in Weyer, which was in effect that the Proceeds of Crime Act had to be read down in such a way that it did comply with the European Convention, then the government took that on board and actually amended Section 6 of POCA so that it does explicitly deal with proportionality. And subsection 5 of section 6 of BOCA now has an additional phrase, and let's look at what that says now. If the court decides that the defendant has benefited, and we're talking obviously about benefit from criminal conduct, it must firstly decide the recoverable amount and then make an order, referred to as a confiscation order, requiring him to pay that amount. So at that stage, what we're saying is that the court decides what the recoverable amount is, and under section 7, we know that the recoverable amount is the amount of the benefit, unless the defendant has satisfied the court that his available amount is less than his benefit. And at this point, we're saying the court must make a confiscation order requiring him to pay that recoverable amount. Here comes the but, if you like. Paragraph B applies only if or to the extent that it would not be disproportionate to require the defendant to pay the recoverable amount. That's the extra bit that was added to subsection 5 as a result of the decision in Weyer. So the court will make an order for the requiring the defendant to pay the recoverable amount, but only to the extent that it would not be disproportionate to require the defendant to pay that recoverable amount. And if it would be disproportionate to require the defendant to pay anything at all in a particular case, then the court will make no confiscation order. So the steps that the court takes are these. Firstly, it decides the benefit. Secondly, it decides the defendant's available amount. Thirdly, it calculates the recoverable amount, and that takes about 1 second to do because it's the lower of the benefit and the available amount. And at this point, we haven't mentioned proportionality at all. Now, fourthly, the court thinks about proportionality. And then fifthly, it makes an order in the recoverable amount unless that would be disproportionate. So we're talking about it being disproportionate for the defendant to have to pay a specific amount. We're not talking about the benefit being disproportionate or the available amount being disproportionate. We're talking about the amount required to be paid to be disproportionate. Now that might lead us to some difficulties, because in a confiscation hearing, the court obviously is addressing the whole issue of what is the defendant's benefit, what's his available amount, what was his criminal conduct, what's the assumed benefit, all these sort of issues are going to be addressed. And that examination might lead the court to consider that it would be disproportionate, let's say, to require the defendant to pay in confiscation. Say he's stolen £10,000 and paid it back, or it's been recovered for the victim, then it would be disproportionate to say that he should also have the £10,000 confiscated as a confiscation order. But where you've got all sorts of different elements of benefit, it might be disproportionate in certain circumstances for some of those elements to be recovered, and it might not be disproportionate for others of those to be recovered. But strictly, technically, the court doesn't have to decide that at the confiscation hearing. All it has to decide is whether the amount, the recoverable amount, the amount required to be paid, which may well be based on the available amount, whether it would be disproportionate to order the defendant to pay that amount. So, strictly speaking, the court doesn't have to make a finding on the proportionality aspects of different elements of the benefit. Well, that's all well and good until perhaps a few years later, you might have a Section 22 application. And at that point, the court, considering the Section 22 application being an application requiring the defendant to pay more money, the court has to consider what would be just under Section 22. And it will be very interested to know if there was a finding that some of the elements of benefit would have been disproportionate to require the defendant to repay those. But that finding may not be recorded in the confiscation order. It may not be obvious as to what the court, when it made the order, thought about proportionality. And that could be an issue further down the line. But the point I'm making, to return to the actual point that I'm making, is that, strictly speaking, proportionality does not affect benefit, does not affect available amount. It's only an issue in relation to the amount which the defendant is ordered to pay. Okay, we hear a lot about what proportionality is not, and it's as well to quickly go over that. Proportionality does not give the court a general discretion to make an order which is just, or which is fair, or which is not draconian. That is not what proportionality is about. The statute very clearly does not give the court, when it is making a confiscation order under Section 6, the statute does not give the judge a discretion as to how much to order. He doesn't have a free hand. In previous versions of legislation, years ago, there was a time when judges did have discretion as to how much to order the defendant to pay. They don't now under Section 6 of POCA. They actually do when we come to Section 22 or Section 23, but that's a different story. So proportionality is not just an excuse to give the court a general discretion to make an order which is just or which is fair. And proportionality does not undermine the legislative purpose of POCA, which has been held to be to remove from the convicted defendant the benefit of his crime. Sometimes we talk about him disgorging the benefit of his crime. So that is the general thrust, that is the general legislative drive, sometimes called the grain of the statute, to remove from the convicted defendant the benefit of his crime. And proportionality does not prevent hardship on the part of the convicted defendant, or indeed hardship for innocent third parties. So, for example, where you've got a family living in a house and the defendant owns, let's say, 50% of that house, then that's going to be, that 50% is going to be part of his available amount. And he may be ordered to pay an amount equal to the total of his available amount. That might mean that he's going to have to sell the house, throw his family on the street, and they will suffer all sorts of hardship, and they're quite innocent of his crimes. But proportionality doesn't address that. It's not a means of making confiscation nicer, if I can put it like that. And similarly, if you have a situation where somebody might have given his son a load of money to go to university, and that might be a tainted gift, and that forms part of his available amount. Well, it's not very nice to have to say to the son, I'm sorry, the pot of money that you have there that you're planning to fund you through university, that's part of the available amount of the defendant. Your assets are part of the realizable property that the court may, if it has to, proceed against in order to get the confiscation order paid. But proportionality isn't about these sort of issues. And proportionality doesn't routinely limit the amount of a confiscation order to the profit from crime, for example, or to the benefit retained by the defendant. All these sort of things are what proportionality is not. So what is proportionality about? Well, what it does is it requires the amount ordered to be paid to be no more than is proportionate to the objective of the statute, which is the depriving of the convicted defendant of the proceeds of his crime. So proportionality will prevent double recovery or a double penalty on the convicted defendant. And that's perhaps one of the key themes of proportionality, this idea that we don't want double recovery, we don't want double penalty, we don't want an over recovery of more than the benefit from the convicted defendant. So, for example, in cases since Weyer, property obtained by crime but returned to the victim is not also payable under a confiscation order. So if I steal a valuable painting, say it's worth £100,000, and it's recovered intact and returned to the victim, then is my benefit £100,000? Absolutely it is. I obtained that painting, it was worth £100,000, that's my benefit. But will it be proportionate to require me to pay £100,000 in confiscation now that that painting has been recovered intact to the owner? No, it wouldn't. And so in that case, proportionality kicks in and prevents an order being made that requires me to pay the value of that painting. In the case of sale, there was a legitimate trading activity. Mr. Sale ran a company, and the company provided materials for railways in particular. And he obtained an order by bribing the person at British Rail or whatever it was who was going to place the order. But having obtained the order, his company provided the goods that were ordered. The goods were of a good standard. Everything was absolutely fine about that contract, apart from the fact that it had been obtained illegally. So the trading activity was legitimate, but it was generated from an illegal bribe. And the court held in the case of Sale that the cost value of the goods properly provided was not a value that Mr. Sale should be ordered to pay again in confiscation, because he provided those goods. He provided that value to the victim. All he was liable to in confiscation was the profit, the gross profit that he had made on that contract. In the case of Harvey, actually a case I was involved in originally in the Crown Court, the defendant's company had a legitimate business of hiring out plant. It was a plant hire company. What was not legitimate was how Mr. Harvey acquired that plant, which he then hired out. He acquired stolen goods and then took the identification numbers and so on off them and hired them out. Now that hiring of those goods generated from that crime was benefit that he was ordered to pay. But what about the VAT which he charged to his customers? Well, the VAT which he charged to his customers, he had accounted for to Revenue and Customs on his VAT returns, and therefore it had been taken into account in the payments of VAT he made as output VAT, and the court held that it was not proportionate for him to have to pay that again in confiscation. That would be a double recovery from him. So the amount of his the amount he was ordered to pay was reduced to exclude the VAT which he had charged to his customers and accounted for to HM Revenue and Customs. And in a very recent case of Andrews, which was decided only last week in the Court of Appeal, Mr. Andrews obtained various employments in the NHS on the basis that he got degrees and he got qualifications and so on and so on. And the truth of the matter was, he'd made a lot of that stuff up. He hadn't got those degrees. He lied on his CV, he lied on his job applications, but for those lies, he would not have obtained those jobs. But having obtained the jobs, the evidence before the court was that he performed them well. He performed his duties well. He provided services to the NHS trusts and so on, which employed him, and he was paid the salary that went with the job. He was performing the job perfectly well. He was paid the salary, and the Court of Appeals said that there would be a double penalty if that salary was confiscated from him. He'd gone to prison as a result of lying on the CVs, and certainly it was the case that but for those lies, he would not have obtained those jobs. But having obtained the jobs, he performed the services, and the employers were happy with the work he did. They were just not happy with the lies he told in order to get in the job. So the remuneration for work properly done by him was not to be confiscated, and in fact, in his case, the confiscation order that had been made in the Crown Court was quashed on appeal. Of course, one always wonders whether cases like that might go on to the Supreme Court. We shall have to wait and see. Okay, that's done proportionality. Let's talk about mortgage fraud. We haven't a lot of time, and it does get a bit complicated. So let's crack on. Where a property is purchased with legitimate funds supplemented by an adequately secured mortgage advance which is dishonestly obtained, and that is the situation that the court accepted was the case with Mr. Weyer, that his deposit monies were legitimate. He told lies on the mortgage application to get a mortgage advance in order to buy a property. So what's the benefit? Well, they said the benefit is a proportion of the increase in the value of the property, pro rata to the mortgage advance as a proportion of the mortgage, as a proportion of the purchase price. So what they're saying is the mortgage advance itself actually was repaid to the lender. So there's nothing to confiscate there in terms of what he's ordered to pay. But as a result of his lies on the mortgage application, he purchased the property and that increased in value, and the proportion of that increase should be confiscated from him. What was said in Weyer was that was the reality of what he obtained by his crime. So, for example, taking some easy numbers, because the numbers in Weyer are not particularly easy, some easy numbers. Let's say a house is purchased for £500,000. There's £100,000 legitimate deposit, £400,000 mortgage, so that's 80% of the purchase price, and that's obtained by false application details. Let's say then that the property increases in value by £200,000 to £700,000. What is the amount that this person should be ordered to pay on confiscation? Well, the answer, says the Supreme Court, is that it's £160,000 because that is 80% of the £200,000 increase in value. And what we're saying here actually is that this is not as a result of proportionality. This is a result of looking at the reality of the benefit that Mr. Weyer obtained. So just to stress that point, it's not a proportionality reduction. This is a reduction in identifying the benefit that he obtained. In this example, the benefit obtained is £160,000. The mortgage advance itself is not benefit obtained by the defendant because the defendant does not obtain the mortgage advance. It passes from the lender to the vendor, It doesn't go into the defendant. The borrower is obtaining an interest in the property he purchased, subject to the lender's interest. Okay, to make things a little bit more complicated and interesting, what about if the property is being rented out? Then if the property is rented out, there's an additional benefit. And the additional benefit is that same percentage of the gross rental income received. So in that example that we just had of the £500,000 property with the £400,000 falsely obtained mortgage, then 80% of the rental income, if that property had been rented out, would have been additional benefit of the defendant. And that follows from the reasoning in the case of Gore, paragraph numbers are on the slide there, where part of the purchase price of a rental property was legitimately funded and part was not. In the case of Gore, it was actually the other way about. The mortgage was legitimate and the deposit was not. But the logic of it being a part of the rent applies. Where a property was originally purchased with legitimate funds but is then subject to an illegitimate remortgage advance. So what we're saying here is the property was purchased, there might have been a mortgage, there might not have been, but all that was perfectly proper. And then down the line, the owner of the property makes an application for a remortgage, and he does that by falsifying his details by a criminal process. So how does the Weyer principle work there? Well, again, it's very similar. A proportion of the increase in the value of the property since the date of remortgage. The increase in the value of the property since the date of remortgage, pro rata to the amount of the remortgage as a proportion of the value of the property at the time of the remortgage. So effectively, it's the same process. Note that we are here assuming that the property exists, it has sufficient value, and that the lender is adequately secured throughout on a real property, and therefore he's either been repaid or he's going to be repaid. So the mortgage advance itself isn't going to be a benefit. So yeah, effectively the remortgage case is treated in the same way as a mortgage case, and the rental income in a remortgage case will also be similarly treated. So the benefit will be a proportion of the gross rental income. And there's a case on that, the case of Reed. If you have a look at that, you will see that was done exactly in that way there. It was a false remortgage, and a proportion of the rent and a proportion of the increase in value of the property since the remortgage was the benefit. Do be aware that the position is different on a property purchase where we have an original purchase, the mortgage is legitimate, but the purchaser's equity is from proceeds of crime. So if I'm a drug dealer and I've made £100,000, and then I apply for a legitimate mortgage to buy a property using my £100,000, which is proceeds of drug dealing, then that position is going to be different from what we've just discussed. And in that event, the entirety of the equity in the property, including the entirety of any increase in value, is going to be benefit. And there's a case on that. It's a case from 2004, and it was approved in Weyer. That decision survives Weyer. So there is a fundamental difference between the situation where somebody has proceeds of crime which they're using as equity and getting a mortgage alongside it, or where they've got legitimate funds and they obtain a mortgage advance for fraudulently. Those are two quite different situations with quite different results. Okay, so how can we help? Well, as you will have heard me say before, Bartfields Forensic Accountants is fully staffed. through the pandemic. We're undertaking legally aided and privately funded criminal and civil forensic accountancy work. Thankfully, it is relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And we remain readily contactable by phone, email, and online video links. The website, of course, is full of useful information. This topic and previous topics are dealt with on the website. All the seminar recordings are put on there. Recording of today will be there in a few days' time. The previous ones are there already. And the links are there for you. We will send you a free recording. We will also answer any questions if you've got. If you'd like to send them to me, my email address there is on the screen. I tend not to answer these sort of questions on the phone because it's just easier to get the facts in writing and to provide an answer in writing, and that's easier for me to do on email. So if you'd like to contact me with any questions, do please email me at that address, and I look forward to hearing from you. And as I mentioned, in a fortnight, we'll be doing a bit more case law. We should be looking, amongst other things, at money laundering and confiscation. Thank you very much for your time. See you in a fortnight. Thank you.